Um, so welcome everyone. My name is Kit Needham. I'm the Director of Project Olympus over at Carnegie Mellon. In fact, I have a new title, Assistant Dean for Entrepreneurship Initiatives. No more money, but just a nicer title. And I just want to welcome you all to the next in our series of Start Smart. And I want to introduce Stephanie, who is my partner in crime. You want to say a few words, Stephanie?
Yes, I'm a professor of practice over at Pitt Law School, and Kit and I have been working together for at least 8 years. And David, I won't even say how long we've been working together. But we are honored to be a part of this group, and I always learn a lot from every session.
And that's really, let me start with that, which is that this will be incredibly dull if you don't interrupt me. So please stop me, and it would be much, much better if this were interactive. So again, interrupt me if you want. Put things in chat, just asking to ask a question, or you can just pipe up if you want to go off mute, if that's possible. And this talk is about, or discussion, I should say, is about leveraging third-party relationships. And the benefit of using third parties to enhance, to accelerate the development of your business. And so, as opposed to the traditional just raise capital and keep going, this can be used in addition to or in lieu of that kind of way to advance your company. So we're going to start with the fundamental question of what is a strategic relationship? Why do you enter into it? Why would you do it? We'll do some general framework and common issues that sort of flow through all these kinds of things. Then we'll go through a couple of different kinds of licenses and in-licenses and marketing arrangements and remarketing arrangements and those kinds of things. We'll go through some specifically, just highlighting the kinds of issues that one has with them. And you'll see again that the questions and answers at the end, but I'd rather not have them at the end. I'd rather have them along the way, if that's okay. And the objective of this is simply for you to think about these as you're thinking about how to expand your business, to give some thought to, well, maybe I should go find a third party to do this, or maybe I could think about doing that. And if you're doing that, you may decide not to, but at least you've given it some thought, and that's really the objective. And if you go think about it, know the pros and cons of doing it and the kinds of issues that you might run into. And I'm using this term strategic relationships, but there are really all kinds of them, right? And this very busy chart has a lot of them. You can, starting from the left, and I'm not going to go through all of them, but you can out-license. So we'll talk a little bit about, particularly in the life sciences area, where sometimes you take a product and you license it to a third party to finish development and commercialization rather than raising capital to do it yourself. So you're basically leveraging a larger organization, very typical in the life sciences. We'll go through an example of that fairly in a little more detail.
David, I'm going to interrupt just for a minute. Somebody doesn't have their mute on, and I can hear like a lot of, I don't know if it's your driving or there's a lot of noise in the background. So if you could
and I'm actually sitting outside. So if that doesn't go away, I will go inside. It may be very well be me.
Oh, okay. All right.
But if it continues to stop me, and I will relocate. There's also in-licensing. So for example, rather than develop a product yourself, you can license the technology into your company. And then, so you can do that. There is a card, but it will disappear. You can contract manufacture. Rather than manufacturing yourself, it's very common to go to a third party and have them manufacture your products for you, because you don't want to go and develop a whole manufacturing facility. It's expensive and it's time consuming and all that. So maybe you get somebody else to do that. Interestingly, if you're interested in that sort of thing, you often, just an aside, you often hear people do that in China. You find, okay, we're going to contract manufacture in China. And as one reading tidbit, I think you've heard me say this before, there's a wonderful book called Poorly Made in China by a fellow by the Midler, I think his name is. It's kind of dated, it's probably about 8 years old. But it's a good lesson in contracting out manufacturing to a third party, in particular China. So it's worth reading. It's an easy read, and sort of it's a how-to, or maybe how not to thing. Distribution, so maybe you don't want to create your own distribution network, so you get a third party to distribute your products. That's fairly common. And it's sort of similar to it up at the top of the representation agreement, marketing agreement, getting third parties to sell your products. OEMs of ours, and we'll talk a little more about them, or value-added resellers, having other people sell products, put yours together with something else, and put them together. So those are all different kinds of third-party strategic relationships we can think about. We're using the word strategic relationship, and they also hear it by joint venture, partner, strategic alliance, all kinds of things. And what we're really talking about is third-party relationships and leveraging third parties. But these words actually, as a legal matter, have legal significance. So when we use this, we really want to be very careful. And a partnership has a very as a defined meaning legally, as does a joint venture and strategic alliance. So just be careful when we use these terms as to which one it's going to be. And the real point behind this is, in my view, is to capitalize on third-party assets, things that you don't have and you don't want to create. Marketing reseller, marketing resources, out licensing, resources third party. In licensing, use somebody else's technology or something they've already created. Joint development, maybe the technology capital, or maybe a lab that somebody else has that's maybe underutilized, so you want to use those. One of the benefits to a startup company is some of the, and this is a little softer of a point, but there's some credibility that comes with it. If you do some kind of strategic relationship, whether it be through a marketing arrangement, and a few of the examples are on the screen here, it creates some pretty good credibility to your company. If you're thoroughly there, there was the Four Moms all the way a few years ago when it did something with Hasbro and announced a deal with Hasbro, that gives it instant credibility. Philips and Immunetrics, a Pitt startup that did it with Philips a number of years ago. You'll see there a company called InvestEdge, which was a relatively small online business that did a deal with Pfizer. The point is that you can get instant credibility on top of the other substantive. I'm not saying that's the principal reason to do it, but it does create some credibility. Some of the other reasons to do it, it's non-dilutive. I mean, I love the fact, rather than go through a traditional round of going and raising a bunch of money and take a manufacturing facility, rather than raise a whole lot of money and taking the dilution associated, because I got to get equity to get that money. A strategic relationship may not be diluted, so I'm not giving up much of the upside. In fact, it's potentially faster and cheaper. Rather than go build that, I mean, I use that example because it's the best one. Rather than go build a manufacturing facility, which is expensive and take forever and get it right, I'll use somebody else to do it. And frankly, other people have already done it. They'll make fewer mistakes. They've already made those mistakes. So why go through that process? So there's some other benefits to doing it. I keep using the word strategic relationships, but I do want to categorize them into two different pieces. One is where you actually create an entity, a joint venture, or an entity. So party one gets together with party two, you create a new entity, and that has a life of its own. And so that business will go off, and it could be a partnership, it could be a corporation, it could be an LLC, it's any kind of form, but that entity has a life of its own. And so each one puts something into it, whether it be capital, IP, people, all kinds of resources. And that company, that joint venture has a life of its own. An example that I have here is PNC, just to give you a sense of Perot Systems, which I was involved with years ago, created a company called Billing Zone. And PNC provided its expertise in the banking business. Perot Systems created its business on its expertise in the technology. They put it together, and they put together an online bill payment presentation and payment system, which was a business of its very own. It went and had its own people working for it. It had its own marketing. It had its own system, its own business. It had its own trademark, right? So it had its own value, goodwill associated with it. That's the most. That's a good example of a strategic relationship where you're creating an entity, a truly joint venture.
David,
Why do you want? Yes.
I'm afraid it's you. We've got everybody muted, so.
Now, why don't we take a moment and allow me to relocate? Okay?
Okay.
Yeah. That's going to take a moment, though.
Okay.
Let me mute myself while I do that, so you don't have to watch me do that.
So I will just, if we want to take this opportunity, if anybody was thinking of doing a connects, that they thought now that they wish they had spoken up at the beginning, now's the time to do it. Okay.
Do you have any upcoming events you want to plug, Kit?
Oh, next week, next Thursday, thank you, is the Startup Job Fair. It is a virtual event. It is again done jointly with our partners at Pitt. It is from 12 to 3, and we have about 30 startups who are hiring, either full-time, part-time, or internship. All are paying. So these could be paid jobs. And so we hope that you find some time to go and check out the companies and show up to sign up for either a brief overview of the company or sign up for one of the one-on-ones that'll be taking place. And our next Start Smart after this is Thursday, March 25. It's on hiring and firing. And so this is, again, the corollary to building your team. And some of you are planning perhaps to get some interns for the summer. Well, there's sort of a right way and a wrong way to do that legally. And so this is a really important program for you to listen to if you're at that stage. All of these performance, this is being recorded, and we are going to be posting the full presentation both on the CMU website as well as on the on Pitt. I think Tiffany, you also post them, I think, on your somewhere on your website, right?
Yep. So I just posted a link in the chat. It'll be at that link, as well as our Big Idea Center website. There's a Start Smart tab. It'll also be there as well.
And are there any big idea events coming up, Tiffany?
Just the Startup Job Fair. That's open to all Pitt and CMU students and alumni. Besides that, we're just in the middle of our Randall competition, but registration has been closed for that.
All right, team.
Three Rivers Venture Fair is coming up this fall. I think the application window is going to be opening up soon, so that's something to be looking out for entrepreneurs wanting to get connected with the venture capital community.
All right, thanks, Dawn. David, are you back with us?
I am. Can you hear me?
I can hear you.
Cool. And you can see me. Cool. And it's quieter.
Oh, yeah. Thank you. And I think
Oh,
you
no.
your screen sort of fast forwarded a little bit. Okay. All right. You're right.
We're good. Cool. So my apologies. Any questions or things you guys want to talk about before I continue, since we were interrupted?
David, maybe you'll get into this later. I was just curious about the differences between a joint venture and a joint development agreement, or JDA. Will you be getting into that, or?
Yeah, we'll talk a little bit later about joint development. Sort of a yeah. Which I also, but I do. I mean, that's very much to preempt it. I mean, that's very much a part of a strategic relationship, a joint development arrangement, and as contrasted with a joint venture. Yeah.
Okay, I'll bite my tongue for a while longer.
No, that's all right. Don't bite. So, and really, the kind of thing that I'm talking about here is a joint venture, where you're creating an entity, which would then be sort of the operating entity, and that this building zone example of mine is a joint venture, and some of the reasons I was about to say was the do it is because if you create that entity, you limit the liability. So if you create an entity to do this, then the liability associated with this new business is limited to that entity if you do it right. So that's kind of nice. As I mentioned earlier, there's goodwill and value associated with that enterprise, so that's kind of nice. Usually it's a deeper relationship. I mean, it really, as a compared to contractual thing I'm going to talk about in a moment, it's a deeper relationship. There's some tax benefits, and frankly, there's accounting too, which is that it'll be separately accounted for. But the real principal reason is that it's a separate entity, a separate business, which is really important. Let me contrast that with a contractual arrangement, and that's a marketing agreement, a joint development agreement that Don was just referring to. It's not creating a new entity and put people in and creating something with its own life, but it's a contractual arrangement. And that's an easier thing. It's a lower investment. It's only a contract, so you're not creating a whole new entity. It's easier to get into because, again, it's only a contract. It's easier to exit. You just terminate the contract. Typically a shorter duration, but again, it doesn't have its very own value. So it's an easier arrangement to get in and out of, but doesn't have its own relationship. All right, a couple things I want to mention about these things generally, cautions. One is I always talk about the little people on your shoulders, and you can decide which is which. One is the investor, and one is the ultimate purchaser, because we're really in part we're creating these businesses, but someday maybe we want to liquidate and sell the company and be really rich. And so when you enter into these arrangements, you want to do it in a way that doesn't undercut the value or create a hazard for a problem for investors. Examples: if you were to enter into a deal where you give exclusivity to a third party in a marketing arrangement, where basically you give them the right to market all of Canada. I have somebody doing that right now, which is what's on my mind. And because they don't want to market Canada, so they're going to hire a third party to market in Canada, and they already have the sales, distribution, and everything else, and they're marketing other products. So this is a perfect thing to do. But that takes a value away from the company. So a buyer and an investor is going to care about that. So you need things that we're going to talk about, like minimums and otherwise. So just be careful that you're not giving away to sort of hampering the growth of the company for the future. And that's I'm sort of getting those two bullets really cover the same thing. And I guess think about time, cost, and risk. It's not free. This does cost money to get in. I've had clients who spent more time getting in than they were in the joint venture because they didn't do enough due diligence, about what it's going to be. So they're not free.
So David, how would one protect against some of those things you cautioned about? Would that be in the articles of incorporation, the operating agreement? Where and how would you protect against those kind of issues?
Good question. And funny you should ask that. But let me fast forward to really two really important parts. One is that in the formation, you want to think through the entire project, how you're going to get in, how it's going to operate, and how it's going to exit. And so think about all the what ifs. How do you get in and out? We're going to talk about that in a moment. So that's part one, good planning up front. And two is doing due diligence, making sure you understand sort of what you're going to try to accomplish with the other party. The expectation, the place I've seen the biggest mistakes is that the two parties have not had enough dialogue about what they're going to try to accomplish. And so they don't understand the business. So this is not a legal issue, it's a business issue. They don't understand what they're trying to achieve in this strategic relationship, and there's a mismatch. So communication between the two is key. So if you document it correctly in the first place, and document doesn't mean sort of dotting the I's across the T's, but ask all the questions that we're going to talk about in a moment, and you have a conversation about what you're going to try to accomplish, I think that those are the keys. And when I look at a joint venture or a strategic relationship, I tend to find it useful to think about it in sort of these three boxes. And there's no magic to it, but I like to think about formation, operation, and termination. And if you really ask yourself up front, what's happening during formation, and I'm going to talk a little bit about each one of these. Formation, when we put it together, how's it going to operate, and when it terminates, because it will terminate. how's that going to happen? What's going to happen? What causes termination? If you think about it in those boxes, I think you'll have done a pretty good day's work. And the formation is pretty easy, right? What's each party contributing? What's each party not contributing, which is really important. I mean, often you're sort of holding back, maybe you're licensing technology for one field of use in a development agreement or whatever it is. And so you're holding back some. It's really important to say what you're contributing, and as important what you're not. And are you granting exclusive or non-exclusive rights? What's actually going in? Operating, who is operating this thing? Who's going to be the responsible day-to-day for it? Are you going to, who makes the decisions? How much more money? How much capital? Who's going to put how much more money in? Who's going to make decisions about the operations of it? Really important. Who's going to decide? Who decides? Sometimes you put together boards or committees, and the development is a joint development committee. Whatever it is, who's going to be in charge of that? What happens if everything always requires more money and more time? So where's the extra resource going to come from? Who's going to put the more money into this? When you make money, which is a good thing, how's that get allocated? And who gets paid? I mean, those are just some of the things that you just think about. And so really thinking hard about the operations is really important. And finally, let's face it, it's going to terminate. When does it terminate? And can somebody terminate for cause when somebody else does something wrong? Probably. But can somebody just walk away from it? Many people want to just be able to walk away. Say, you know what, I don't want this relationship anymore. And that's okay, but you got to build it into it. What happens if that's the case? What happens to the IP? Who gets what if it happens? Do you sell it to a third party, or does it go back to the people? Let me use my billing zone again, just because as a good example to continue on with. If the Bureau systems put the technology into billing zone and it doesn't work, does it get that IP back, or do they sell it to a third party and split the proceeds? Really important question.
So David, I'm sorry.
Go ahead.
So all of ours they're little itty bitty startups that don't have a lot of money, and strategic partners tend to be these big companies that have a lot of assets and they have a lot of money. And the first question in some cases, what the small company obviously wants to work with the big company. Not always does the big company want to necessarily see the full value, but sometimes they take advantage of their size. I mean, I've actually had one that kind of began to slowly but surely lose control of its company because the large company was so dominant. So how do you protect against that?
Yeah, so that's it's a really good question, and it's the what I call the sell without selling problem. Which is you've given enough control to them that you basically sold the company. That is a risk, and so let me sort of think about some things with you out loud as to ways to protect against it. One is that often those kinds of companies, when they do this, want things like rights of first refusal on the sale of the company, rights of first refusal on to do other things, to market, whatever it is, to expand that relationship. So one thing is to draw a line very hard at that part. So when they do what I call scope creep, where they start trying to take advantage of those things, you try to very hard to not give that. That's point one. Point two is that you try not to give them veto rights or control over the company, what you're doing. So you have to take a hard line on upfront negotiations, not be bullied by it. That's part two. Let me also say that it's really important to, when you're negotiating with the big companies, that's probably the most important thing, is to have a choice, to have an alternative. Because the real influence, the rights that you're going to have are going to be in that piece of paper that you negotiate up front. And if you have to do the deal, then you're going to have a really lousy piece of paper. So, I talk about the one client that you got a choice at some point to sell, do a joint, take money, or sell, take money, or to license to a third party. And if you have choices, then you're going to be in the best negotiating point. So the point is to walk into a negotiation with alternatives. Couple other things. I guess one more thing I want you to be careful of when you do these, and I'm not sure we cover it in the slides, but is that doing a joint venture or a strategic relationship with a large party will have an impact on other companies doing business with you going forward, their competitors, for example. So maybe a block for others doing business with you. So it's the flip side to my point about instant credibility. So that's good. The bad news is you're now associated with it. So in Pittsburgh, if you now have this wonderful joint venture development, et cetera, with UPMC, that's good. But there's another half of the city that will have nothing to do with you. So you just got to be careful, and that may not be okay, but you just not know that going in. So that's another piece that you need to protect against with the big guys. Some of the other things we talk about a little bit here is the disputes. And this is a good one. I mean, so I think it's important to have systems in place where you have constant communication with them so that you know what you're doing, so you don't get to the end and there's a dispute. Let me make sure I covered yours before I go on. Kit, did I cover your question? I think I see you nodding.
Yes, yeah, I did. Yeah, I was on mute.
Okay, cool. But let me, as I go through the rest of this, let me bear that in mind. And what I'm going to do is, as I run through some of these others, I'm going to point out little guy versus big guy and how you can sort of protect in each one of these. Because this example for avoiding disputes is really important, because we can't afford a dispute with the big guy. We will get creamed. And so we want to avoid the disputes, really important. So how do we do that? And the way you do that is to have clear understandings up front, which we talked about earlier. You have information exchange and meetings from time to time, so you're not going off in different directions. You all know where you're going. So if you build into the relationship those kinds of meetings, whether project meetings, et cetera, that's very helpful. Aligning people's interests is hugely important. I look at arrangements and I say, okay, are both parties going to make money at the same time? Do they both have the benefit from it? If they do, it's a higher probability of success. If you build in a situation where their interests are not aligned, that's a problem. And so I often look at because people are very creative in the arrangements they build, but the problem is if the classic is the years ago, the classic is the guy that does syndications, limited partnerships, and that kind of stuff, right? Where they're getting a management fee. So the investors aren't getting any money, but the manager is getting a management fee of X%. So they're making money, but the other guy isn't. That's not an aligned interest. So you want to look at these and say, okay, are they going to make? They make money, I make money. So that's just a good way to make sure you avoid it or minimize the probability of a dispute. I can't emphasize enough the next one, which is quality partners. It's really important if you're going to do one of these things, do a little due diligence on who you're getting into bed with. Who are you doing business with? Yeah, they're good people. Is it a good company? They have a history of litigating against the small guys, basically walking in, taking over their stuff. So that's important. Think about when there is a problem, build in an escalation mediation. And what I mean by that is maybe there's a committee of maybe the head of your small company and somebody with some clout in the other company who you've developed a relationship with. So if there's a problem in the operations, you can escalate it to that group. So that's a nice to build in mechanism, again, to avoid the disaster. Again, what ifs? What if we're late? What if we don't run? Ask all those kinds of questions. Think about all the bad things that can happen, which lawyers are trained to do, but business people are trained to say, what are all the good things that can happen? Lawyers are trained to say, what are all the bad things that can happen? so to go on the bad side for a little bit and think about all the bad things and make sure you build it in, and build in exits, make sure there's a way to get out. Those are some ways to avoid disputes. And again, we can't afford a dispute. But you should build in arrangements if there were a dispute that at least attempts to level the ground, the ground for all of us. So think about where you're going to fight. I mean, if you're a small company and you're out of Pittsburgh and you're going to fight, and the thing says you're going to have to go to California to fight, that's too expensive. I mean, what are you going to do? Have to hire everybody there? So if you're in Pittsburgh, you want to fight here in Pittsburgh. Arbitration, I don't love arbitration, but the good news is that it's a cheaper thing, and you can't. And the problem with courts is you can appeal it, so the litigation goes on forever and ever. So maybe that if you're dealing, and I've done this, I'm not a big arbitration fan, but in certain circumstances, particularly this one, I may very well want a quick arbitration, which is less expensive and has finality to it, that perhaps we can't afford. And what I don't love as the small company is, often you'll put in an agreement that says the loser pays legal fees. Traditionally, if there's no piece of paper, then everybody pays their own legal fees. But often, and it's very common that they put in that the loser pays. Well, the problem with that is that, again, as the smaller party, we could never afford to pay the legal fees of the other one, so I can't afford to fight because I can't ever risk losing. So that's not a good thing for us, so we don't want that. And important, the last one I'm going to spend a moment on, which is really important, is what happens during the fight. Really important. If there's a dispute, what happens to the technology or the arrangement if it's in place? And I'll give you an example. Suppose for a moment that there's a license and you license your technology from a third party because you don't feel like developing it yourself, so you license it. And there's a dispute as to whether or not you have defaulted under that license. Maybe they thought you were supposed to pay a royalty, you didn't pay a royalty. So the licensor, the other party, goes to terminate that license because it's entitled to, because you're in breach. You don't agree that you breached. You don't think you had to pay royalties on that. Well, if you get a letter from them saying we terminated the license, you're out of business. Then there's an ambiguity as to what happens. So often when you have that kind of an important license, I put a provision that says that the license remains in effect during a dispute, and only after the dispute, and I have an opportunity to cure, can it be terminated. That's really important because it can't cut the umbilical cord out from under you, right? So really important. Just as we talked, that's one way to protect against the big guy sort of smashing you. All right, I'm going to spend. Let me see what we're doing time-wise here. All right, cool. Cool. And one more thing, as long as we're talking about fighting, and I don't want to talk about everything about fighting, but we ought to think a little bit about, okay, if we fight, what remedies can one get? It's one of my favorite subjects. If I were to sue, what remedies? And obviously one is I get damages, I get money associated with it. Sometimes you want what the third one, which is injunctive relief, the court to say, thou shalt do something, and you can put that in the agreement. We had a client once who sold software, and they built it on and they resold somebody else's hardware with their software. And they had a long-term contract, and the hardware vendor decided that he kind of liked that software business. This is kind of nice. So they basically built their own software and then terminated wrongfully the license, the reseller arrangement. And our client, the software developer, had pretty much built its business on that long-term relationship that the hardware vendor had committed to. We went to court, and the court forced the hardware vendor to sell the hardware to the software vendor for a period of 3 or 4 years thereafter. Forced them, said, thou shalt do it. And that's because we had an agreement, and they said, so that's important. So the point behind that is it's important to think about, if things were happen and they default, what are the remedies, and create disincentives to default. When I talk about liquidated damages, you talk about the big guy. So they have your software, they have your IP, and they say we're just going to use it for something else. We're just going to do it. So you can sue them, but maybe you want to put in liquidated damages, so that that's with a big number, right? That creates a disincentive to do it. So that's the point there. To build in some disincentives to do that. Questions on any of that before I go on? One issue you get into a lot of this is assignment, and it's both with you. So I want you to think about this as you think about it. Is the person you're sitting across the table from may not be that person tomorrow. They may want to assign the contract or the relationship, and can they or can they not do that? Similarly, can you assign the contract or the relationship? Let's take the first one first. It's not funny to wake up one day and have your competitor be the other party to that joint venture or that business. So you want some kind of perhaps prohibition on an assignment to a competitor or somebody else. Maybe you had you did the deal with a big company and they decided to assign this to a small company, sell it off, and that's not the deal you had. So you want an anti-assignment provision because you want to know who your partner is. On the other hand, on the flip side, from our side, it's really important that it be able to be assigned, particularly in connection with the sale of the company. If we go to sell the company, I want to make sure I can assign this contract to the third party. Make sense? So just think about sales, about assignments when you're doing these. People often just overlook that. All right, let me go through a couple examples unless somebody has something you want to talk about before then. And one is a sales representative marketing agreement. And this is pretty straightforward. This is simply a contract that says, look, I'm going to sell my stuff to customers, but I'm going to hire somebody else to be my sales rep, to basically pay them a commission or some fee to find customers for me. So as you'll see in the box, the company, we ultimately sell to the customer, but I have hired a sales rep to find me customers, and I'll pay them some kind of commission. The sales rep doesn't take title. He's just acting as an agent to find buyers for me. And why do I do this? I do this because there are companies out there that have large organizations, large sales forces, underutilized sales forces, and they want the ability to we might as well leverage their expertise and their resources. This is done in the pharmaceutical business. It's done in all sorts of things. We have a company that sells of all things HVAC systems. They use this, right? I mean, it's all over the place. And it's similar to if you hire your own sales guy or saleswoman. Do you hire your salesperson? This is an external version of that. So. But you don't have to hire all these people, so that's kind of good. When you enter into those deals, they often some of the things you want to make clear is the amount of effort that sales group is going to expend on your business. It's not funny to enter that kind of a deal. Again, the one I'm just working on today, which is why I'm about this. Okay, sorry about that. Let this disappear. Thought I had that off. The sales, the guy that's doing it in Canada and has a sales rep in Canada, it would not be funny to enter into a long-term sales representation agreement with somebody and have them go to sleep and do nothing. So you want some milestones, some obligation to use commercially reasonable efforts to actually sell. And they usually want some kind of exclusivity. It's not funny for somebody. They don't want to take over a territory and then have somebody else competing with them in the product. So they usually want exclusivity in a certain territory. That's very common. But in order to get that exclusivity, again, they have to have some obligations of sales, minimum sales or something like that. Again, I'm leveraging their expertise and their resources to do that. You want to make sure they're not making a whole bunch of representations about your product that they're not authorized. That's pretty easy. And, you know, part of this one, they're using your trademark. So it's really important to police your trademark and make sure they're using it right? It's because you don't want them off using it for some other purpose. You know, so the bad news is, you know, you have to pay them. The good news is it typically is only based upon sales. So I always say you can't overpay a salesperson because sales is critical. And so if you pay them a percentage, that's fine. You have to figure out what that's a percentage of and when you pay, but that's all fine. You got to figure out termination provisions, and sometimes you want to be able to terminate for cause and without cause. Short term, the sales reps want a long lead time for first termination. You want to be able to terminate it shorter, because if you terminate somebody, that's the last minute they're going to pay a lot of attention to you, and so you need to have a short term that's good for the company. And there are some state, you should be aware that there are state regulations on these things that one has to double check. And unfortunately, it's state by state, country by country, that limit the time that you can terminate these kinds of sales rep arrangements. So you got to make sure that's the case. And the last piece on, yep.
Okay, I just wanted to make a plug.
Yep.
So this is the legal side, but we also have the business side when you're trying to figure out how much should be salary, how much should be commission, and
Yep.
how to actually do everything David's talking about. We have two experts, Ralph Massaro and Bruce Smith, particularly for the CMU students, but I'm sure we could take on some Pitt ones as well, who will literally sit down with you and help you figure it through, depending on whether it's a hardware sale, software sale, the length of the pipeline. So you got to do the legal side, but if you need help on the practical side, we have people can help you with that.
Okay, good. And you'll see my note there at the end. There is, and I'm not going to do a lecture about the franchise, but when you're thinking about these, the goal is to not be a franchise, which I call the F word. Franchises are heavily regulated. You have to do all kinds of this, state regulated, federal regulated. You got to give people a prospectus, and it's really quite a chore. And if you want to be a franchise, that's okay. Then it's a different business model, but usually you're not to do that. But if you give somebody, if you tell them how to do their business and you license a trademark and do that sort of thing, it begins to feel like a franchise. So you just have to be careful. There's not, and some states have a fairly broad definition of franchise. So the point is, when for example, we a couple of years ago went to terminate a franchise, and I forget in what state. Tried to terminate a sales rep agreement. The sales rep defended on the basis that it was actually a franchise. And while we ultimately won, we spent a lot of time arguing about whether it was a franchise or a sales rep. So the point is that when you do this, just make sure that you at least thought about that and structured in a way that's not, it will not be characterized as stuff. Is that. Again, we talked about sort of, okay, the beginning, the middle, and now the end. What happens when it terminates? Often, sales reps get tails, which is commissions on sales that happen afterward based upon the relationships that they've created while they were the sales rep. Eminently reasonable. That's very typical, but requires a huge amount of thought as to how much, how long, who gets the benefit of it, et cetera, because you're going to replace that person with somebody else, and you don't want to pay double commissions, and I got to be able to put somebody else in that spot. So you got to know what that obligation is going forward. So I'm not going to spend a lot of time on it. Just know there's tails, and you need to think about what that is. Do you get the customer list back? Essential. That customer list is really important. So I want that back from that party. That's always not easy. And confidentiality. If you gave them a lot of confidential information, then you need that back. I will go back to one point, Kit, to your point about big versus small. And it sort of goes to this customer list that occurs to me that it's be careful in which you think about what information, confidential information, trade secrets you're giving to the other party in the deal. If you can do a joint venture or whatever arrangement it is in a way that minimizes the amount of the sort of the core data, core information, core things that you have, the less risk that the big company will use that in a way that's not consistent with you expect your arrangements are. You know, you'll have an NDA. You always have an NDA. But if you're trying to enforce an NDA, that's not where you want to be in life, because that's you know, we can't afford to fight it. And I always joke that if you're trying to enforce an NDA, it's like being at the bottom of the well yelling for help, and I don't want to fall down that well. So if you can structure your relationships in a way where you don't give them the critical, important, you know, the source code, if you will, or whatever it is that's critical, I think that's very helpful. And will not allow them to sort of disregard you going forward. That was just a bit of a.
So,
as I keep,
David,
yes.
In a practical situation, one of the entrepreneurs I'm working with is working on a specialized gum. And, you know, gum manufacturing is a very unique process. So she'll probably have to find an existing third-party contractor to make her gum for her.
Yep.
So she can go into a non-disclosure, non-compete, but you know, she'll be giving them basically her secret
Yep.
costs. How do you ensure beyond a non-disclosure, non-compete? What's the best way to protect in a situation like that?
Yeah, that's so hard, isn't it? I mean, that's the classic case where you're giving them your trade secret, and there it is. So, couple thoughts.
What you said earlier: choose your partners wisely.
Right. But supposing, but the worst, you know. So, a couple things that you might think about. One is limiting who and the other party needs to know that confidential information. In other words, why don't we go down a layer and say, okay, who there really needs to know that? And maybe you can limit to a handful of people, or just, you know, 2 or 3 people, or just whatever it is. So let's limit the risk that within that organization. Point one. Point two is make sure that they themselves have the kind of protections with their employees, those people that they're supposed to have, which is the non-disclosure, non-compete, et cetera. So let's do another little layer of due diligence to make sure that the other party has all those kinds of protections in place that we would hope that they'd have. So that's point two. Point three is that if it's possible to do some kind of a non-compete during the term and for a period thereafter, that's helpful, because that means that they can't take it and compete or do something, or you know, if it's within a, and typically in that kind of case, maybe it's a special kind of gum, so they wouldn't be competing with that kind of gum for a period of time. So you sort of get that covered off. So that's another way to think about it. Another thing to think about is just think about liquidated damages of a very large number. Which is because if there's a breach of the non-compete, in addition to equitable remedies, there is a big number at risk, and so they know that if they trip that, there's a big number. And frankly, that you may say, okay, well, it's a big company, they'll care about the big number, but actually, if it's big enough, I'm okay, take it. So I don't be cute, but I mean, make it a big number.
That liquidated damages is based on a theoretical, not based on actual revenue.
Correct.
Okay.
Right.
But
And whether
make it painful.
Make it painful. Correct. And there's a concept in the law. So the lawyers here are going to all sort of jump on me, because in order for liquidated damages to be enforceable, they're actually not supposed to be punitive. They're supposed to be sort of an estimate of damages. So have a reasonable basis for damage. So there should be some basis, and never use the word punitive, and have them agree that this is the liquidated damages. And frankly, you might even think about, if you really want to get, I don't want to sue for it, and I did this once, get a letter of credit to support that. So if they default, I'm going to go to the bank and I'm going to collect a letter of credit, and I'm going to pull down that money. And that'll create all the disincentive in the world to do it. And I actually 2 years ago, actually for the first time, actually drew on a letter of credit. I've gotten over years. Actually, I had to flew somebody to California to present the letter of credit and actually collect on it. And it's huge, right? I mean, you do it. And that creates a disincentive. So that's a way to do it.
Wouldn't you get pushback on that? Because
Of course.
when a company opens up a letter of credit, it takes working capital away from their.
Correct. But if it's a big enough company, it's not. First of all, the fee is relatively de minimis.
Okay.
It's 1% or something like that a year. It's not a big number, and if it's a big enough company, that shouldn't be an issue, right? So that shouldn't be a big issue for them. But yeah, it does have that effect. But I've got it, notwithstanding that. So that's that point. There are clean rooms. I mean, you can require that they have, they only, again, certain people go into this room. It's protected. I mean, one of the things is security. So you want to go through really carefully what security they're using in this company to secure that trade secret and what they're doing, so that nobody can get in and out physically, let alone sort of virtually. So go through that kind of a process. And have inspection rights. I mean, go actually inspect where they're manufacturing it, and make sure you have a right to inspect it, so you can go see what's going on. Preferably without notice, so you can show up so they can't clean the place up before you get there. Obviously, and this is aside from the NDAs and all that stuff. Those are what come to mind. There's probably more, but those are the ones that come to mind at the moment.
It's very helpful. Thank you.
Mm-hmm. We talked about marketing agreements, sales agreements. Then there's remarketing agreements, and this is a different concept than having somebody who's your agent sort of selling. This is basically you're selling your product to a third party, who then remarkets it to the customer. So it could be as simply as a distribution agreement where you sell it and then they resell it. And so they actually take title and possession. It could be a original equipment manufacturer or a value-added reseller where they basically take your product, add something around it, maybe morph it, put a bunch of products together and resell it, or actually just add something to it and resell it. But either way, you're selling your product to them and they're reselling it. Different concept than having an agent, a sales rep. A couple things about this. One is they often use a different name when you do that, right? So you're losing some of the benefit that you have as far as your trademark, because part of your goal is to get your name out there. And so you want to think about whether you're going to impose your trademark or not impose your trademark. I mean, again, the thing that's on my mind today is the Canadian thing. We had a long discussion about whether they could white label or use some other name, or did they have to use our name when they resell it? Really important. And it's okay either way. I just want to make sure we think about it. You lose control. They can sell it for whatever price they want. They can provide whatever they provide whatever warranties they want. So it's pretty. So you lose a lot of control with that kind of an arrangement. You want to be very careful about sort of being able to, if you're going to. Well, let's stick with that for a moment. I do want to, I did say this, but I'll reiterate, you lose control over their pricing. And typically you can't tell a reseller how much they can sell it for. You can suggest it, but you can't tell them that because it has nasty antitrust issues. So generally you can't do that. So there's a possibility of them undercutting the rest of the market. And so you got to be careful as far as that goes. I mentioned inventory control. It's, part of the question is when do they pay for these products? Because if they, you have to manufacture, you have to, if it's not a software product, but take your chewing gum, I got to have all these packets ready to go. And so if I want to resell it, so who's going to pay to manufacture those, and how do we control when those orders are made, and who pays for it, and if it's available, and it could be very expensive. So that kind of an arrangement needs to be taken care We'll talk about licensing in a moment. And that's kind of boring. Let me move on to out licensing. So that's remarketing. Out licensing, again, I mentioned that we do, this is common in the life sciences area. I have an example, and this is where you basically license out the technology to a third party who then does the commercialization, future development or commercialization of the product. And I have an example there on the screen of a client of ours, Canop, who so a few people on the call are familiar with. And they had developed a product that was a drug that was got through a phase 1 and phase 2 that was quite good for late stage ALS. For ALS. So they could have at that point either raised additional capital, sold the company, or licensed the technology to a large pharmaceutical company, which would do then the phase 3 development and the commercialization. They chose, for a variety of reasons at that point, to license it to Biogenetic, the pharmaceutical company, to do the phase 3 and then and then ultimately to commercialize if the phase 3 were successful. So that's sort of a perfect example of licensing out your technology for somebody else to complete the development and or commercialize. Some issues with that are, one is it's hugely important to figure out exactly, again, which technology is it. In their case, for example, they had a couple of different drugs. Theirs was only that drug, not others. There's the territory. Are you doing this for just the US, ex-US? What territory? So it's important to think about that. And those have very different values, right? Is it the field of use? Is it being licensed out for everything or just one type of use? And this is something that's worth considering as you're developing a company, because it may be that you have different fields of use that your product, your technology may be useful for. And you may decide, you know what, I'm going to focus on this product, this field of use. And then I'm going to license to a third party to exploit it in a different field of use. So, and that's also very good. For example, use the Canop example. Perhaps they would license it out solely for ALS, but they would not be licensing it for other potential indications for which that drug would have efficacy and may have efficacy. Really important, because you'll focus on one and not another. And that may have, and in the software world, you may decide that your software has different applications, and I'm going to license it out for development and commercialization in one application, but not other applications. Really, a really useful thing to think about. Exclusivity, really important. Are you giving them exclusive license or just or non-exclusive license? And by the way, does that mean with respect to the licensor as well? Is the licensor now precluded from using their own software or product for that purpose? We've talked about transferability and term. I'll let those go. Hugely important that if you're going to license your technology out because you don't want to develop it, commercialize it yourself, that there's milestones of performance. Again, this is beginning to see some themes in each one of these, right? We don't want them to sit on it. It would be really a shame if, use our Canop example, Canop had licensed to Biogenetic. Biogenetic decided to sit on it, not do the phase 3 trial, not commercialize it if the phase 3 trial were successful, and just basically sat on it. That would be quite unfortunate. And so you have to have milestones and performance requirements for the licensee to make sure that they actually do it. Usually pay royalties. And folks, you have dealt with this before from the flip side, right? If you license from the university has all this in there, some commitments to hit milestones, make sure you're not going to sit on it. They have some regulatory reasons to do it, et cetera. And similarly, if you're licensing out to a third party, you got to pay royalties. And so how much of those royalties, if we're licensing it out, third party is going to pay royalties to us. What amount, what royalty base, are there minimums? We want minimums. What happens to the joint products? I mean, there's all those kinds of royalties that you want to think about. You have to think about improvements, developments. If they improve or develop the technology, who gets the right to use that? Does that come back to us? Because there will be improvements. And are they royalty bearing? And you can spend an incredible amount of time thinking about that. So those are just some of the things to think about. One thing that's sort of interesting, if it's a patent, how long does the royalty stream last if you're licensing it out? Sometimes people say for the life of the patent. Sometimes you try to go beyond that. And you can do that if you tie it to some other thing like a trade secret or something. So that, how long does that royalty obligation go on? And obviously there's all kinds of IP questions, which is who's really important though, who's going to prosecute, make sure the patent, who's going to make sure that the patent continues, you can pursue the patent, right? And on the downside, if somebody infringes that patent, if you've licensed it out, who has the right to sue and for infringements of that patent? Again, licensing it out, just those kinds of things to think about. Questions there before I move on? Checking my time. Okay. Another alternative is, because you don't want to develop it, is to license things in from a third party. You all, many of you have experience in this because at the first part of your business, you licensed technology from the university. That's your very first in license. And so there's similar kinds of issues. That's usually, why do you do it? Because it's a critical asset. It's something you want, and you don't want to go develop it, and so you license it in. Or they may have a patent on it or some kind of IP protection, so you need to license it in, otherwise you can't use it. Sometimes you want to just expand your product base. So you may decide, okay, I've got product A or B or C, but I need to create more. I want to create more of a broader base of products. Maybe it's because I want to make it more diverse to risk. Maybe it's because diversify the risk associated with the business. There's a variety of reasons you might want to license another product from a third party. Again, we already talked about the shoulder person. If you license it in, really important to pay attention to the ability by the licensor to terminate, because you don't want that to happen. And it's important to pay attention to improvements. If you improve the technology you come in, that you've licensed in, what does that mean? Do you have to pay royalties on that? Do you not have to pay royalties on that? So improvements are really important to think about on the licenses. That's in license. It's pretty similar. It's just the flip side of the out licenses. So I won't spend a lot of time on that. Don, you asked earlier about development agreements. And development agreements are where you agree with a third party that you will develop or they're going to develop your technology either collaboratively or one does it for the other, either way. But that idea is that somebody else has the capacity to develop the product that you may not want to buy, pay for, or otherwise. So you're going to license them to do it. Classic cases, a developer, a software developer, a third-party software developer that I'm going to have go develop my software for me, right?
Well, there's also the capacity of who's got capital. I was working with a company that had a very interesting technology. They produced a leather manufactured out of recycled leather, and a large branded footwear company that was, known for their taking a strong stand on sustainability. They were very interested in the technology, and I said, "I'm glad you're interested in the technology. Why don't you consider giving them some money? Because these guys have no money." And they gave them a significant amount of money on a joint development agreement. Basically, they said, "Here's our specs. If you can hit our specs, we'll buy some product from you." So it was basically a joint development agreement with a specific intent to develop a product that would meet the company's specs. So it was basically R&D write-off for them, but it helped my company get going.
And when they developed the product for the third party, who owned what they developed? They did, or the company, or the third party did?
I had counseled them to maintain control. The company that paid for it had exclusivity, limited activity, not eternally, but for a number of years within that footwear space. But the company was free to sell it to other industries.
Right. And so let's pause there because that's so important. And it's really a very nice model, which is that if you can get a third party to fund your development in exchange for exclusivity within a field, is a lovely model. And you got to be careful and do it right.
Yeah.
And you got to make sure you own the IP subject solely to that thing you've given back to them. But that is that's non-dilutive capital. You haven't given up equity in exchange for it. And it's almost like a prepayment, if you will. I mean, I love, it's similar to when you can get customers to pay for a study or prepay for products. Those kinds of things are really wonderful. And so I want to pause on that because that's a sort of a third-party relationship arrangement where you're getting the third party to pay for your development. They'll want something back, but if it's limited, that's really a wonderful role. I'm trying to remember the name of the company. I'm showing my age, which did this in Carnegie. How was it? All the way back, and that basically did it for their software. And they had one. Ford put some money in, so they had an exclusive in the automotive space. They had one in different areas, right? And it was great. It was. I mean, you have to really pay attention to what you've given away, but that's a wonderful model. Okay. So these kind of development agreements, whether somebody else is developing it for you, is important to make sure that the developer that you're having develop is going to do a quality job. I mean, so this goes to making sure you're the third party that you're dealing with. We talked a little bit about confidentiality, NDA, the use of confidentiality agreements. Really have they're usually a couple pages long, but they really only have 2 sentences that really count. One says, "Thou shalt keep the information confidential," and 2 is, "I won't use it for any other purpose." So if you're going to have a third party develop for you, you want to make sure that there's some kind of confidentiality arrangement. Now, we just talked about ways to sort of bolster that, but that's important. And it's important to understand who owns what's created. It's essential that what you bring to the table, you own, right? I mean, and so the question is, okay, but when they develop, who owns those developments? Or whoever's developing it, who owns the developers, whether it be you're developing for somebody else or you're going to have a third party develop for you. And it's pretty important for this company, if you're going to hire a third party to develop for you, it's essential that you own that IP coming out of that. And we have a current assignment of that IP, because when we go to, remember my 2 people, this buyer or the investor, we have to be able to show them that we own the IP. Really important.
If I could, David, just to get on the soapbox a little bit, when I work with a lot of early stage companies, and they tell me about their funding strategy, they say, we're going to go to Blue Tree or these other angel groups and raise money and then do this and that. The thing I like about joint development agreements is you're getting funded directly from a potentially huge customer. And it is a way to get your business growing quickly in a non-dilutive way. And so, I think a lot of early stage companies need to consider joint development agreements as a funding strategy. The key is finding companies that have the problem that your technology can solve, because these companies are very anxious to get these problems solved, and it's often cheaper to do a joint development agreement with a upstart third party than to spend a lot of money internally trying to do it themselves. So I'll get
totally agree.
Now.
Totally agree. Yep, totally agree. Yep. Okay, so some of the issues that one wants to sort of address in Don's joint development arrangements are, it's important to what's going into it, what IP is being sort of used, what background technology versus new technology, and you know, we talked a little bit about these decision-making steering committees, et cetera, on these things. So during these joint development arrangements, you know, who's deciding what's developed, et cetera. But we've talked about that before in the others. Again, if you're doing joint development, I love joint development, but if you're doing a joint development arrangement, really important to understand who owns it, who's going to use and commercialize it, what royalties, who pursues the IP, arranging for. And let me tell you what doesn't work. Usually, sometimes, not usually, but sometimes people will say, okay, this is easy. We will, if we create something, the two of us together, it will be a joint ownership of patents. We will both own it jointly. And that is a classic case where 1 + 1 is less than 2, because what a joint ownership of a patent means is that each party can exploit the patent, use it, which means that neither one has a non-exclusive license. And so you can't go off and license it to a third party on an exclusive basis, and they can't go to license it to a third party on an exclusive basis. So generally, that's not great. And it's also unclear who has the right to enforce the patent and what obligations you have to each other. So a better model is to have one party own it and then have a license, a clear license to the other party. So if you, for example, take Don's example of the big company doing a joint development agreement with the small company, let's have the small company own the IP that creates out of the joint development. We will license back what's created to the big company for within its limited field of use, and have the right to own and control the IP going forward for all other purposes. That's the best model for us.
David, just jumping back to the joint development, or I'm sorry, the joint venture situation, would your recommendation be to have that joint venture own the IP? Or, I mean, ideally, if the small parent company could retain it, that would probably give them more cards to hold, but
Right.
OEM probably would insist that the IP go with the joint venture. Do you have any thoughts on that?
Yeah, so yeah, you're exactly right. Best case, we own it. Second case is that, I mean, if there's if the joint venture is truly a business unto itself, which is that you're going to, you know, there's an entity there that's going to have a life of its own, a joint venture is best. I mean, is okay. And I don't have any problem with that. But then you're going to get into a lot of negotiations with the big company about control of that, funding, et cetera. And I think there's a good shot that you're going to end up on the short end of that stick. So I'd rather, frankly, I'd rather let the big company own the IP, license it, and have a very clear license to the new company, to the small company, of the technology that's developed in a very clear way that allows us to use it in a without termination, without royalties, worldwide, whatever it is, and have a clear license to the small company, which then I can use going forward. The joint venture, I think we're going to lose control over time. So to your very first question you asked me, I'm sorry, that Kit asked me, I think I'd rather just get a clear license than do a joint venture if I have my druthers.
So David,
Sure.
maybe this is a George question, but my understanding is that when you file your patent, that you have your inventors, and if by law you have to list who the inventors are and what percentage of their contribution. So let's just say it's a joint venture and it's one of the employees from big company and one of the employees from small or startup. We're the two inventors on that. And then, but then,
Yep.
So that's a difference between filing the patent, but then who owns the patent I'm confused.
Correct. So let's distinguish ownership from invention. And the inventor, you do have to disclose the inventor. Really important. And just let me pause there, because if you misstate the inventor on a patent, it can then be invalidated in the future, even if you do it by mistake. Really important. So I have seen situations where people have attempted to invalidate significant patents because they have knowledge that the inventor was incorrectly stated. So start there, really important. Right, that's inventorship. That's very different than ownership. And typically those employees of each of those entities will have signed an agreement whereby they assign their inventions to the the respective companies. So now I have big company, little company actually owning the patent, right? So the inventors are now disappeared because they've agreed to assign their rights to the company. We will file a patent showing them as the inventor, and then they will have assigned that patent to the company. So now the companies own it. Now we have to talk about, okay, once it's in those companies, now what happens to it? And what we're suggesting is that there's a couple different choices. One is that those IP go to a joint venture, the one that Don was just talking about. You create a new entity which owns it. Another is that one of the two companies owns it and then licenses it to the other company, the other party. And the question we were talking about is, okay, does we house that IP in a little company, big company, or a joint venture, right? And I'm suggesting if I'm the small company, I have, in order of priority, I prefer to own it and license it to a third party, to the other company. That's probably my preference. Number two is actually for the big company to own it and get me a clear license to the small company, so it's clear what my ownership is. Third choice would be in a separate entity, a joint venture, and that's my least favorite because I'm very fearful that a small company is going to lose that use of that from that third party, and I'm going to lose control of that, which is the kind of thing you were worried about earlier. Because that was long-winded. Sorry.
No, that clears it up.
Okay. Other questions on that? We talked a little bit about joint development.
Okay, we have
Yep.
7 minutes left for, oh, look, my goodness.
How about that?
First time you've gotten through a deck. So.
How about that? How about that, huh? So you can tell when I start sort of going through the, but anyways, yes. So my point, y'all should pursue, consider, and exploit. I mean, Don did much better, some examples of really good reasons to at least consider these. Let's open up other questions that people have, if any. Well, you all know how to find me if you have questions.
Yeah.
David, I'll ask one. You know, the advice I give all the entrepreneurs I work with is, in all things in life, choose your partners wisely. In terms of your financial partners, and you know, the subject today is third-party relationships. A best way to do research on who is a good partner and who would be a partner to avoid?
Yeah. So, yeah. So let me tell you some of the things I suggest to people that they do, that they do on that. Obviously, you need somebody who's interested, and so I'm going to leave it to you folks to find the potential partners, right? Because you want to find the space and find people that would have an interest in your technology, and that's in some ways almost easy. And I have one caution that I want to come back to, remind me to on sort of approaching those parties. But once you find the partner, how do we know they're good partners? And so there's a couple of things that you can do. One is, it's as easy as just doing research on litigation and see how litigious are they. Have they have a history of suing, being sued by partners? So look, just do a litigation search, which is fairly easy. That's point one. Point two is to ask for other partners, other people with whom they've done deals, and talk to them. You know, we're doing a deal now where we're selling a company, and this company had acquired 5 other companies in the last 3 years, and we've talked to every one of them. And we didn't ask them. Obviously, it's self-serving, right? You're going to ask them, and they're going to tell you, and they're not going to tell you the people they screwed. And so, I mean, there's a little bit of that problem going on. But if you ask the right questions of people, you're gonna be able to tell. Ask them what, you know, how were they? Were they honest up front? What were the surprises? Not by the were there surprises. What were the surprises? You know, what were what was the best of thing that happened in this relationship? What's, so you know the kinds of questions you ask. So find people with whom they've worked and do a lot of due diligence that way. And then I guess finally, spend a lot of time with them talking about what they're going to do. People can be superficial for only so long. And so if you sort of ask them what ifs and talk about all these kinds of things, it will come out. So to spend a lot of time with them going forward. And by the way, talk to more than just the single person. Remember, they'll be gone. If you're talking to an organization, they'll be gone tomorrow. And so then you end up with somebody different there. So ask if you were to disappear, who's your replacement? Talk to the whole team, not just the person that you're dealing with then. And that, find out who's really going to be doing the work and you're dealing with, and deal with it and talk to them. So those are some ways to do it. I want to pause there for one moment. One interesting question that you didn't ask is, if you're going to go approach these people, how do you have a conversation with them in the first place without divulging I'm asking a question without knowing how I'm going to answer this yet, by the way. But one of the questions you raise is, how do I tell them without telling them too much? And how do I embrace this, embark upon this discussion? Because often the companies won't sign an NDA up front because they're afraid of sort of signing NDAs and therefore finding themselves subject to a non-disclosure agreement for stuff that they may already know or they may already interfere. And so they feel like they're placing themselves in a problem where there can be claims against them for receiving information, the confidential information from you and breaching a non-compete, an NDA. It's a common problem when dealing with large organizations. So you have to figure out a way to tantalize them without giving them your secret sauce and the confidential information. And you need to be, that is an art. There's no fine science to it, but it's an art and something you have to think about when you're approaching large organizations. If your idea, the simple concept and the idea that you're giving them and the simple saying the idea is a problem, then perhaps you want to think about filing a provisional patent application before, if it's patentable, before you talk to them. And so think about that kind of how am I going to protect this if they're not going to sign an NDA? So I have had people, by the way, they want to do that. We have filed a provisional patent application before they've embarked into that conversation. So we're on record of having done that beforehand. So just think about, the better, that's one solution. The other solution is to think about non-confidential ways to entice them.
So David, we have one, I know the time is sort of up, but we have one question in the chat, which is, do you have any thoughts on doing due diligence with potential co-founders in addition to what you've already mentioned? For example, what do you think about doing a background check or asking for a credit report to check their likeliness to keep commitments? Or is that for the next hiring and firing?
No, it's a fair. The concern is exactly the same as to what, and there's a legitimate concern. There's a legal concern, which is in order to raise capital, you have to make sure that your principals are not bad boys, which is that they haven't done anything with the Securities Commission or anything else in the last period of time. So I think that talking to people and getting references for co-founders is a very sensible thing to do. And I encourage people to do that. I don't think people do that enough. So I think it's a very important thing to do. And we've talked before about making sure you ought to be doing due diligence with respect to your co-founders on the IP, making sure they actually own the IP that they're coming to the table with, and talk about that, really important. And I frankly have no problem with doing background checks on people. They're not that expensive, and it would not be funny for people to wake up one day and have your co-founder not be who you were hoping they were. And so doing background checks on co-founders is a sensible thing to do, and they're just not that expensive to do. And if you need, I got a guy.
My father threatened to do that for me when I was dating.
Yes, I'm, yes, right, that's, yes, yeah.
Anyway,
All right,
so
other questions? If any.
well, there are no more in chat.
Okay.
So I think between Don and I, we asked enough questions.
Oh, I appreciate that.